Yes, I salute you all. Thanks for listening and thanks for watching. So basically, today we are under the sale of goods, and the topic of emphasis, or the topic that we are going to look at, we are going to look at the Nemo Dat, the Nemo Dat Quod non Habet. Basically, that's the Nemo Dat rule, and this rule it is under Section 29 of the Sale of Goods and Supply of Services Act. Section 20 what? 29. And Section 29 of the Sale of Goods, they say that sell by a person, not the owner. Basically, when you read subsection 1 verbatim, you realize that they say that where goods are sold by a person who is not the owner of the goods and who does not sell them under the authority or with the consent of the owner, the buyer acquires no better title to the goods. Basically, when you read that subsection of section 29. And what am I trying to imply here, or what am I trying to put in bold? That for you to sell goods, you must have good title, or you must be the owner of goods. That's what the Nemo Dat rule says. You get? So basically, under the Nemo Dat rule, it portrays that you must be the owner of the goods, or you must be the good. Actually, you must be the owner of the goods. And when you realize the Nemo Dat rule, we have the case of Candy versus Lindsay. Candy is C-U-N-D-Y versus Lindsay. Under this case, it provided that the seller, actually it was even the principle that was laid under that case, that the seller cannot transfer good title. Actually, they say that the buyer cannot acquire better title once he gains goods from a person that is not entitled or is not the owner, who has not got authority from the original owner to sell the goods. So basically, note that in mind, and that's the Nemo Dat rule, or the Nemo Dat Quod non Habet. So basically, that's the rule, that you cannot transfer. There's no sell by a person who doesn't have good title. Good title, that is ownership. You don't have the credibility of ownership of that particular property that you are trying to sell. But however, we are going to look at the exemption to the general rule, because realize that every general rule has what? An exemption. So we are going to look at the exemption to the general rule. And one of the exemption that we are going to look at, it is sell by an order of court, or sell by statute, or the power of statute. We get basically that is the one exemption. It is sell under the court order or power of the statute, or by a court order. So basically, when you look at the sell by a court order, actually you have to read section 29, subsection 2, paragraph B of the Sale of Goods and Supply of Services Act, under the power of statute. And realizing sell under the court order, read section 33, subsection 1. You realize that it gives the sell under court order. Basically, realize that it is court selling. Court doesn't have a good title, but the selling, it transfers a better title. Court is not the owner of that particular property, but it transfers a better title to the buyer. Read section 33, subsection 1. You get even the power of statute. Read section 28, subsection 2, paragraph B. You get sell under court order. Read the case of Lama versus Fawcett. Is it Fawcett? Fawcett. You get read that case. Then that is one exemption. The second exemption is by agency. You get agency basically. We shall use the concept under agency, whereby an agent and the principal, who acts the other acts by himself. The principal is liable for the acts of the agent. You get what the agent does, it is presumed that it is the principal acting by himself. Now, in this essence, where sale is by an agency or under agency, an agent can transfer a better title to the buyer. Okay, these are the exemptions under the Nemo Dat rule. And we have the case of Flocks versus King. Flocks is F-O LKES versus King, whereby the plaintiff entrusted his car to a mercantile what agent for sale out, and and basically here realized that this agent that sold the vehicle, he transferred a better title to the buyer. Reason being that he was interested. We use all the types of agents under the question of agents: presumed, apparent, emergency. All those categories of agency must be adhered to. Basically, note that in what? In mind. And when you're in the case of Locks versus King, it gives you that narrative whereby they held that the buyer had obtained a good title to the car from the agent. Reason being that he had got authorization from the owner, the agent had got authorization. That is by agents. Then we have sell under a voidable title. It is provided under section 30. You get section 30. Where there is sell under voidable title, the buyer gets a better title to the goods. But however, here deals whereby the buyer has bought the goods under honest and good faith. You get, without actually the narrative that there is defect to the title, or the seller has a defect in the title of ownership. You get, so the buyer can acquire what? A good title to the goods. You get, so basically note that in mind. And another exemption, we have sell by a seller in continuing possession. Sell by a seller in continuing possession, provided under section 32, subsection 1. In this essence, realize that here, what am I trying to mean is that the seller, however much he has sold off the vehicle, but he's still in possession of the what? Is still in possession of the goods. And here the buyer what must prove that he was not aware of the previous sale. You get, that's what the buyer must prove, that he bought the goods in an honest belief, without the perception that there was a previous sale of that particular what property. Basically there he can acquire a better title to the goods. We have the case of Eastern Distributors Limited versus Golding. Under that case, court held that the seller must remain in possession as a seller. You get, and in this essence, he can transfer, he can sell, but it is the onus of the buyer to prove that he bought the vehicle or he bought the goods in an honest, in a good faith, without knowledge of the previous what sale. That is a seller in continuing what possession, basically. Then we have sell by a buyer in continuing possession, provided under section 32, subsection 2 of the Sale of Goods and Supply of Services Act. In this essence, what you are trying to look at is that the buyer has bought a particular goods, but before even completing the sale of goods, he has been given possession. That's what they are calling continuing possession. You get, so when he sells those goods to another buyer, that buyer will gain a better title without knowledge of the defects of the previous sale. You get, note that in mind, provided under section 32, subsection 2. We have the case of Lee versus Butler. Lee versus Butler. Under this case, Court of Appeal held that the equivalent of the provision applied where the buyer was in possession of the goods under an agreement to buy the goods and pay them in installments. You get, whereby he bought the goods and they agreed to pay them in installments, but he had not finished the installments. So in this essence, what we are trying to mean in this essence, they try to prove that he could transfer a title once the buyer doesn't have knowledge of the previous defect in the whatever. So we have sale, another exemption, we have sale in an overt, in a market overt. What do I mean in a market overt? In a market overt, that is a public space It is sale in a public space authorized by law or a legal provision, basically. If a buyer comes and purchases a commodity in the market overt, however many it has defects in its title, the buyer acquires a better title, and the owner cannot reclaim that title from the buyer who purchased that particular title in a market overt. A good example is you go in the market overt and you purchase this particular pen, but whether the person that sold to you had defect in the title to that particular goods. For you, the onus is you portrayed your desire to actually you bought that particular commodity in utmost good faith, which means however much you buy this pen which had defects, the owner of this pen, the true owner, cannot claim it from you. You get, because you purchased it in an overt, in the market overt. Read the case of Hill, Hill versus Smith. You get, read that case. It gives that element of a market overt. You get. So another exemption that we have Estoppel as an exemption to the Nemo Dat rule. Estoppel, as you hear, it is being to be estopped. You get, that is Estoppel, and it has three categories: Estoppel by words, Estoppel by conduct, and Estoppel by negligence. It has three categories. Estoppel. Estoppel, basically, it is what you do is the one that estoppels you from denying someone a better title. You get. So what you do is the one that estoppels you from denying someone from claiming a better title. So basically, estoppel, it is denying the owner from denying the buyer a better title that he had gained from the purchase or from the sale of what? From the contract of sale. So basically, one of it we have estoppel by words. When we read the case of Henderson versus Williams, estoppel by words, it is what you speak that estoppels you from denying the buyer a better title. You get. Estoppel by words, the good example that I can use is that if at all you use words saying that, you know what, I've given the responsibility of the other one to sell this vehicle, what and what. And if the other person sells that vehicle, you cannot claim that this person didn't have the better title. Sorry, didn't have a good authorization to sell the what? The goods. That is estoppel by what? By words. Your words are the one that are hitting you, basically. So you cannot claim, you cannot deny the buyer from gaining a what? A better title. You get. So note that in mind. That is estoppel by words. Read the case of Henderson versus Williams. Then we have estoppel by conduct. You get. When you read the case of Honorable Mabo Bakeine versus Uwasa Investment, that is a good case that I've referred you many times to read it. Under that case, we saw estoppel, it was by conduct, whereby this was Muyingo that sold the vehicle. But the owner, which was Uwasa, was claiming that Muyingo didn't have a authorization or didn't have mandate to transfer a good what? Title of that vehicle. But however, through the conduct that court analyzed, they realized that Muyingo had authority to transfer a good title to Uwasa. You get? Actually, to rewind my words back, the case it is Were Fred versus Kanga Limited. Get, sorry, I was mistaken about the case, but the case is Were Fred versus Kanga Limited. This is the case that I've told you to read. You get, it is more so good, more so here on the Nemo Dat rule, but on the exemption, it deals on the exemption of agency, first of all, and also the exemption of estoppel by conduct. Even estoppel as in general, whereby Muyingo was given, actually, Kanga Limited was saying that they had not authorized Muyingo to sell that vehicle. But however, realized that in this quotation, the conduct that appeared, Muyingo had a good authorization to sell the what? The vehicle. Because the question was, the question that were in quotation, where did he get the logbook? If a person was, he appeared to be an agent of the owner, you get. Because even if in the layman's understanding, if you go to a bond, the person that approaches you, it is prima facie that he's acting as an agent of the owner. So that case of Wedefred versus Kanga Limited, it is a good case. And it deals on sell by what? By Estoppel. This by sell by what? Estoppel. So not that case very well. And in this essence, what you have to realize, or what you have to bear in mind, is that under the case of Wedefred versus Kanga, court realized that the Wedefred had acquired a better what? Title to the goods. So they estoppelled Kanga Limited from denying Wedefred a title to the goods. Then the last one is estoppelled by negligence, as still under Estoppel as an exemption to the Nemo Dat rule. Estoppel by negligence. Basically here deals, they say that actually this one deals whereby someone is estoppel because of his negligence. But negligence only acts where someone had a duty of care and failed to perform that particular duty of what? Of care. So they can estoppel him because of his or her negligence. For example, you are the owner of the vehicle. Let me give an example. You are the owner of a particular, okay, let me use a vehicle because under sale they normally use vehicle. So you are the owner of a particular bond of vehicles, but every time you walk, you are leaving your stamp with the people around you. You get. Unfortunately, now that person that maybe those stand boy, he has sold off the vehicle because he had the official stamp of the bond. So realize that if me I buy a vehicle from that particular kid, which means I get a better title under the estoppel by your negligence. You had a duty of care to ensure that that stamp doesn't fall in wrong hands. But you have left the boy to be with your stamp, which means he can transfer a title, a better title to any buyer that approaches him or her. So basically note that in the case of under estoppel by negligence, we have the case of Mercantile Credit Limited versus Humbling. Mercantile Credit Company Limited versus Humbling. Humbling is H-A-M-B-L-I. Humbling. Basically here, there the court held that negligent signature of a document can only give rise to estoppel where the person owed a duty of what? Of care, as I had explained. You get. And the case of Wilson versus Mearson, the case of Wilson and Mearson versus Pinking, court held that Mosso negligence deals in the negotiable instruments, checks, what and what. It is more so under checks. You get. So basically, those are some of the exemption. That is the exemption of the Nemo Dat rule and the general rule as we have discussed under the Nemo Dat Quod non-Habet. Basically, that is the Latin maxim. But other than that, thank you for listening and thanks for watching. Stay blessed.